All right, I think we're ready to start.
Calling the meeting to order.
All right.
First order of business, we need to go in a closed session.
No closed session today. Minutes.
Minutes, is there a motion?
Move approval.
Second.
Discussion. It's been moved and seconded. Going once, going twice on discussion, seeing none. Do we need a roll call?
I will call the roll,
Even though we're all here.
even though we're all here. We're required to do roll call votes because we've got a, we're just going to, I don't want to confuse things.
Okay.
Commissioner Jenkins is not here today, so I'm not going to call her name when we do roll call votes. I also will not call the name of absent legislative members, just to simplify the process. Carrillo.
Aye.
Carrion.
Present.
Cubas.
Aye.
Heber.
Aye.
Calra. He's not here, sorry. King.
Aye.
McAllister.
Aye.
Simpson. Aye. The minutes are approved. Thank you.
The subcommittee meeting from last time.
There were no actions. I'll just report that we had a separate memo 2341 that just summarized what happened the last time we tried to meet here in this room and lacked quorum. So there's nothing really in that requires any decision of the commission. It's just information only.
Is there anything from that we're going to retake up?
Yeah, there's a number of items that we're going to retake up. They're all agendized.
Is it time for Brian?
Well, if that's what you want to call it.
It's Brian's time.
Brian's time.
I would like to call the matter that's next on the agenda, which is recognition of the executive director, Brian Hebert.
We recognize you.
Thank you.
So,
Kristen, in honor of your retirement and your many years of sterling service to the state of California, we have a few things. By the way, have you checked your email this morning?
I did, but not recently.
Okay, you should look at your email.
Okay.
Kristen.
So we have, it's all wrapped up nicely.
A
but
Senate resolution.
Yay. Resolution from the California legislature. I'll try not to break it. Honor Brian for his service. I actually have the text, and so I don't need to read off of this, but this is from both the Senate and the Assembly. So
Nice.
you have the members, the legislative members of the commission, as well as your local legislators.
Oh,
So they're all on this resolution. Let me hand this over to you.
yeah,
And I can read the text into
why
the.
don't you,
are people taking pictures?
I'll take.
We
Yes.
can also take a group picture when we break as well, so that we can get all the commissioners
Let's do
and
that.
All right. Very pretty. Thank you.
so. Read off the resolution.
Place of honor in your house.
By the Honorable Richard D. Roth, 31st Senatorial District, the Honorable Bill Dodd, 3rd Senatorial District, the Honorable Cecilia Carey, 4th Assembly District, and the Honorable Ash Kalra, 25th Assembly District, relative to commending Brian Hebert. Whereas Brian Hebert is retiring as Executive Director of the California Law Revision Commission, and it is appropriate at this time to highlight his many achievements and extend to him a heartfelt thank you for a job well done. And whereas having ably served the California Law Revision Commission for 27 years, Brian Hebert started as a staff attorney in 1996, accepted the role of Assistant Executive Secretary in 2003, and was promoted to Executive Secretary, now known as the Executive Director, in 2006. And whereas renowned for his thorough legal research, keen analytical skills, masterful writing and statutory drafting, cogent oral presentations of difficult legal concepts, and overall constructive approach to law reform, Brian Hebert spearheaded extensive improvements to the law that governs common interest developments, including important substantive reforms and organizational changes to make that law more accessible for the millions of people living in common interest developments across the state of California. And whereas Brian Hebert's sharp insight into the complexities of laws governing estate planning and his ability to discuss them in a clear and understandable way resulted in an exemplary record of contributions in that area, including reforms related to no contest clauses, donative transfer restrictions, disposition of an estate without administration, the intersection of estate planning and marital dissolution, revocable transfer on death deeds, and more. And whereas a consummate professional, Brian Hebert played a leading role in numerous other statutory reforms to improve the clarity, fairness, and effectiveness of California law. including laws relating to unincorporated associations, administrative rulemaking, fish and wildlife, and exemptions from the enforcement of judgments, to name just a few. And whereas during Brian Hebert's tenure as executive director, the commission approved more than 60 final recommendations containing proposed legislation, almost all of which were enacted, revising over 4,000 code sections spanning a broad range of topics. And he helped the commission produce several informational reports for the California State Legislature and the governor, including a major report on application of the Government Claims Act to charter schools, and a comprehensive report on state and local agency access to electronic communications. And he was instrumental in effectively launching the commission's ongoing study of antitrust law in the modern technological era. Whereas over the course of his tenure with the commission, Brian Hebert also developed and implemented many improvements to the commission's administrative procedures, while being resourceful, patient, and creative, and leading the commission as its executive director for almost 17 years. And he guided the agency through repeated state fiscal crises, the COVID-19 pandemic, and the creation of an entirely new law reform body, the Committee on Revision of the Penal Code. And whereas Brian's model professionalism, calm demeanor, straightforward manner, diplomatic leadership, judiciousness, and thoughtfulness have earned the respect and admiration of those who have had the good fortune to work with him, including numerous staff and members of the California State Legislature. Now, therefore, be it resolved by Senators Richard D. Roth and Bill Dodd and Assembly Members Cecilia M. Aguiar Curry and Ash Kalra, that all best wishes for a long and happy retirement be conveyed to Brian Hebert, along with sincere appreciation for his years of dedicated and exemplary service to the people of California.
And you're a true public servant and true son of California. I speak for all of our colleagues here in thanking you for your long and meritorious service to California. You will be missed.
You are very welcome. It's been a pleasure and an honor. I really enjoyed the work. It's always been interesting, if only in sort of a law nerd kind of way sometimes.
Best kind.
And it's always been satisfying to know that even though things sometimes move slowly and progress is modest, there's always progress. This is a body that gets things done and makes improvements for the people of California. And it's been like I said, my pleasure and honor to be a part of it. I've surprisingly enough enjoyed running the administrative and staff side of it as well, as stressful as that is sometimes.
Well, the commissioners put together something for you. When you get a minute when we're not doing things, check your email.
Okay,
There's good news.
good. Thank you.
It's from all of us. It's something that we hope makes you happy in retirement.
I appreciate that. Thank you.
It's not a gold watch.
It's not a goal.
Yeah. I asked about a pony and you vetoed that.
Thank you, everyone.
Really sincerely, thank you.
Well deserved.
I have to say, you've grown nicely. I remember when you were a tadpole new hire. Yes.
Yeah.
That's right.
I remember I significantly changed my hairstyle once and you came into the room and stopped dead and said, "What are you, the Madonna of the Laura?" Some of those memorable moments.
Put that on a cocktail napkin.
Thank you.
Would you like to give a report?
Sorry?
Would you like to give a report?
Yeah, are we done with that item?
We'll praise you for the
Any
moment.
more adulation? All right, sure. Moving on to the executive director's report. Lot of administrative stuff's been going on. That's pretty much all I've been doing for the last few months. Haven't been doing any study work. So let me say first regarding commissioners that Commissioner Jenkins let me know she's ill. She's not able to attend today. So we won't have her, unfortunately. Commissioners Creo, King, and Simpson have all been reappointed by the governor. Always appreciated people re-up for another term after having experienced it once at least. And Commissioner McAllister, after multiple terms, two, many years of service on the commission, is stepping away. And so we have a vacancy and I'm talking to the governor's office. They have somebody in mind to fill it. So it won't surprise me if we have that vacancy filled for the December meeting.
Jane cannot be replaced.
Jane cannot be replaced. And Jane serves today during the 60-day holdover period, statutory 60-day holdover period. An update on facilities. I think I mentioned at the last meeting that we have dissolved our multi-year relationship with King Hall Law School, where they were providing us with space and facilities, and we were working with their faculty and staff. They continue to grow their own programs, and real estate on the campus is tight, and they decided they needed the space we were occupying for one of their new programs, I believe a labor law clinic. So that was added to my plate at the last minute, so that was fun. And we have, I think at this point, successfully moved out physically from our space. We are now, as of yesterday, leasing office space in this building. If Cara were here, I would thank her for her graciousness. She stepped up when she heard we were having this need, and she volunteered to work with us on that. And we're also still in the process of working on replacing our IT hosting services that were previously provided by UC Davis. And we are in talks with Legislative Council about that as well. The studies, we have decided to temporarily table the reorganization of hazardous materials so that we could reassign staff to work on the landlord-tenant project. The landlord-tenant project has a statutory deadline. The hazardous materials reorganization does not. And so I've been feeling a little uneasy about whether we would be able to meet the deadline for the landlord-tenant if we didn't start it sooner rather than later. Last item in the report is on the budget, which is we're okay in the budget, but it's tight. And we're going to squeak by in the next fiscal year. I had thought about asking for more money in a budget change proposal, but when I ran the numbers, we had barely enough to stay afloat next fiscal year. And so it wouldn't be proper for us to ask for more.
Is the new space more expensive?
Sorry?
Is the new space more expensive?
No, it's less expensive.
Oh, great.
Yeah. But the year after that, I suspect we're going to be in the red. And I've already started talks with Department of Finance about that problem. And unfortunately, I'll be handing it over to Sharon Riley, my successor as executive director, to handle a tiny amount of money in the big picture. But to us, it would be critical to staying solvent. That's the entirety of the executive director's report. I see that we are now within 6 minutes of 10, which is our time certain to start the presentation on antitrust, but we don't yet have Senator Gianaris, who is our first scheduled speaker.
I think we could do elections pretty quickly.
Yeah, that's what I was going to suggest. Move to the elections memo 2334.
Calling for the election of officers. I would like to nominate Ambassador Hebner to take the chair, and I would like to nominate my colleague Xochitl Carrion to take the vice chair position.
Accepted. Thank you.
Except,
You accept.
thank you.
Second the motion. It's been moved and seconded. Any other nominations? Going once, going twice. Any
I will call the roll.
Discussions?
Oh, sorry.
Seeing none.
Okay.
We may call the roll.
Carrillo,
Aye.
Carrion,
Aye.
Cubas,
Aye.
Ebner.
I as to the deputy, abstain as to the chair.
Okay.
You're an honorable man.
King,
I to both.
McAllister,
Aye.
Simpson.
Aye.
Okay. Carrion, do you want to change your vote to the complicated split?
Sure. Yes.
But the converse.
Yes.
And for the record, for what it's worth, Ambassador Hebner has ruled that I must continue to gavel the meeting for the remainder of the meeting.
Yeah, we're not changing horses before you finish the agenda.
Just want to make clear, I'm not exercising, cross the Rubicon powers here.
Very good. No argument from me. We're still waiting on Senator Gianaris. We have 4 minutes.
Commissioner suggestions?
Sure.
Are there any commissioner suggestions that we could do quickly? Going once, going twice. I recommend we go off the record for a few minutes, take a quick break, come back at 10 sharp.
Okay.
Can we do that?
Comes down to,
Excuse me for the interruption.
you missed recording my introductory remarks there, but that's okay.
Yeah, sorry.
That's all right. But the bill basically comes down to a notion that I came to after significant research here in New York, that our antitrust laws are broken, certainly at the state level here in New York, and I don't dare to opine on the state of California's laws. That's for you all to determine. But we felt that our antitrust laws here in New York were antiquated and weren't keeping up with the times. But in doing so, we also realized that our federal antitrust laws and rules are also lagging behind. We're seeing the Biden administration's Justice Department now being more aggressive and trying to enforce the laws that are on the books, but they are also hamstrung by the rules and judicial interpretations that have whittled down antitrust regulation over the last several decades. I think in the next segment, you're going to hear from advocates on the federal level on this important issue, but I think New York and California in particular have a unique status in the nation as states that have not hesitated to drive the conversation and move standards, even that end up getting implemented nationally when we think it's the right thing to do. Obviously, your auto emission standards are legendary for that, but there are also other examples of our two states leading the way. I like to go off topic for 30 seconds and talk about one example. I had a law passed several years ago to protect airline passengers. We were told that we couldn't do it because it was federally preempted. We did it anyway and required planes to go back to the gates if they were stuck on the tarmac for 3 hours. We were battling out in court, and lo and behold, the Obama administration enacted a rule nationwide, which is still in effect, which now requires that after some horror stories about people being trapped. So that is to say that I don't think either of our states should hesitate to play a leadership role and not back down just because the federal government also has responsibility in the area. So getting into the meat of the proposal, my bill does a couple of things. One is bringing New York's standards in line with some of the problems that are existing now in the new economy. And one is addressing actions by unilateral actors. At this point, New York requires some kind of conspiracy or collaboration between two entities to restrict competition. And that takes the forms that are very familiar to people in the field over the years. But what we're seeing more and more now, especially with big tech, is unilateral actors acting to restrict competition. And that also takes a number of forms. Probably the one that is most familiar to people is something called leveraging, where an entity controls not only, for example, the products, or has an interest, I should say, not only in the products that are marketed and sold to consumers, but also in dictating the ability of that consumer to see that those products are available through searches, for example. And so when a particular company will prioritize products that may be inferior, maybe more expensive, what have you, for consumers, and that's what the consumer predominantly sees and sees first, that of course affects their purchase of that product. And we have heard from a number of small businesses who have complained of that type of behavior and have been boxed out of markets, who are supportive of our legislation here in New York, exactly because this is not, and I'm sure we'll talk a little bit, you'll hear some more about entities that are opposed and why they're opposed. But in fact, we have seen small and medium-sized businesses clamoring for this, some publicly and some privately, because they're afraid of the repercussions of supporting something like this more openly. But the fact is, this is by definition a pro-competitive proposal that seeks to give small and medium-sized businesses and corporations an opportunity to compete fairly and not be boxed out by the largest players in the field. The one thing we also are trying to do, because unilateral conduct is somehow covered federally as well, not covered by New York State. And so we're trying to obviously get ourselves there in New York. But the big change that I think has caught a lot of attention, more academically, if you will, is the change in the standard for antitrust violations from one of the monopolization standard we've become very familiar with, and in fact has been chopped to bits by numerous court interpretations. But we would change it to something called abuse of dominance, which is a familiar standard. It exists in Europe and other parts of the world, and has allowed for more aggressive enforcement actions in those jurisdictions. Because what we're seeing is a struggle to adequately police the massive consolidation that's occurring in the new economy. And the existing standard makes it very, very difficult for regulators to go and bring enforcement actions. Like I said, we're seeing the Justice Department now attempt some more aggressive steps in this area. But if they were armed with an abuse of dominance standard, that would completely change the game and re-empower consumers, small and medium-sized businesses, and I think ultimately lead to a better result for all Americans. Now, whether the federal government does that or not is obviously up to them. But as I mentioned earlier, if a state like New York or a state like California, or frankly any state in the country, takes the lead and moves to that standard, what you're going to see, of course, is the regulators in those jurisdictions moving faster than the federal government can move. And very quickly, it would drive the conversation in a way that I would argue the founders intended the states to behave as laboratories, as places where we can be a little bolder and faster than the federal government, and hopefully set an example for them to follow. And that's what we're trying to do here in New York. Admittedly, this has generated the expected backlash that people like the next presenter, I'm sure, will present to you, and that's because they represent those who would be more regulated, and of course, people who are and entities who are benefiting from the current status quo, who have the power and the wherewithal and the freedom to suppress competition, would choose to do so because it would mean greater profits for them and more money for their executives and their shareholders. And that's what they're in the business of doing. I don't fault them for advocating for themselves, but it's our jobs as policymakers to look at whether that's in the best interests of the public. And I would argue that it is not. And you see it when lined up on one side are all the big bad players who are dominating so much of our lives right now. And on the other are regular people, small businesses, medium-sized businesses, workers, because I should also touch on the monopsony standard we included in the bill. And those are the people that I think need protection, as opposed to those who are most empowered and need government's help the least. And so that's what I believe public service is about. I do want to circle back and talk about the monopsony issue for a moment, because we also not just deal with the anti-competitive behavior of these big companies on their competitors, but also on their workers. And we would establish a standard that would allow enforcement against those who become too dominant relative to the labor force. Because when you have a situation where an individual entity is so omnipresent and so dominant in the as it relates to potential employees, obviously their bargaining power is severely limited. Let's say, for example, Amazon is the only game in town in a particular small town or city, and you're either working for them or you're out of work. Your ability to negotiate a fair salary is obviously restricted in that circumstance. And so we would allow that to become subject of regulation as well. This is a very complicated subject area, and we have been very open to receiving constructive criticism and comments. We've amended the bill. We probably will amend it again because we have heard from some industries that we're not trying to touch, who feel that they might be subject to additional enforcement as a result of the language in the bill. And so we are in the process of making sure we're not getting at things we're not intending to get at. But overall, I think it's a very sound piece of legislation, and I would encourage you to follow suit in California. We'd be happy to work with you further if the issue starts getting developed more fully, to learn from each other and get to a place where we can hopefully change the dialogue going forward. So I don't know if I've taken up 15 or 20 minutes or how long, but if it's okay with you, I'll pause there and stick around for questions later.
That's fine. Thank you. Mr. Stock?
Thank you very much. Let me first say that I would thank the commission for having me here and allowing me to so-called share the stage with the Honorable Senator Gianaris, for whom I have the utmost respect. I believe that Senator Gianaris and I share the same goals, ensuring that our state and our nation have the most competitive marketplace possible, better and high-paying jobs for low-wage earners, and a more equitable distribution of wealth and power. And I very much appreciate the discussion here of proposed legislation in New York. And I think the question that I'm focused on is, will that legislation take us in a forward direction for these goals, or would it instead take us backwards or have collateral consequences for the economy, such that, so to speak, the proposed cure is actually worse than the claimed disease? I have a couple of slides. I'm going to try to put them up periodically, but I'll try not to keep them up the whole time, so that you can see my face, or maybe that's a negative if you can see my face. But here's my face on the slide.
There you go.
It's lovely.
Before I get into substance, I just want to emphasize the perspective I'm taking today. I'm not here to say that the antitrust laws are perfect and don't need to be changed. I'm not here to say that we don't need to do anything to curb the power of large companies, to address the problem of inequitable distribution of power. My background, I'm in private practice right now. I have been for most of my career, but I've also spent 3 years in state antitrust enforcement. I was the chief of the Antitrust Bureau for the New York Attorney General's office under Attorney General Schneiderman. It's the best job I ever had, and it's the work I'm most proud of doing. I brought cases that the FTC and the DOJ didn't have the willingness to bring. We won those cases. I have a deep belief in the power of antitrust enforcement and state antitrust enforcement to do good and to act to prevent excessive concentration of power. And I'm going to assume, for the purpose of this discussion, that there is a good case for change, that too much power has been concentrated at some of the largest companies in the world, and that we need strong antitrust laws. But I do want to emphasize that, again, emphasize that as a former antitrust lawyer, former antitrust enforcer, the antitrust laws in our country are some of the most fundamental laws that govern our nation and the daily life of business. We have a lot of regulatory regimes in our country that govern telecom, pharmaceuticals, healthcare, specific industries. But the antitrust laws, they determine how everyday businesses work. They govern every type of relationship and every type of industry. And as Justice Marshall said, it's kind of like the Magna Carta of free enterprise. So we should be really careful and thoughtful if we're going to make a change, and be sure that we know that this is very well thought out, and that the benefits outweigh the risks. So Senator Gianaris, again, respectfully suggested the only reason to oppose the legislation is out of concern for big companies or not having the public interest at heart. Well, you can judge, you can judge me on the merits of my arguments. I am not here to say that we need to defend big companies. I would like to address the legislation on the merits, whether it's good for the public, whether it's good for jobs, equitable distribution of wealth. That's the test. And again, I'm operating under an assumption that we need to do better. So first, let's talk about the abuse of dominance provision. This is changing the standard of the legal standard between from a rule that says it prohibits unlawful monopolization to it prohibits abuse of dominance. I've tried to organize my concerns about this change into 5 basic buckets. 1, what exactly do we mean by the definition of dominance? Number 2, would that kind of related, would that definition cover local businesses, smaller business that are not the target of the legislation? That I think, as Senator Gianaris has acknowledged, that is worth considering. And then the third question is abuse of dominance. Well, what is abuse, and does the statute properly define what abuse is? Number 4, I want to express my concerns that this novel statute does not limit its enforceability to public entities like the New York Attorney General or the California Attorney General's office that we probably trust to do the right thing in all or almost all cases. It hands this sweeping power and this sweeping new standard to class action lawyers, plaintiff lawyers, and anyone who wants to try to bring a case, whether intended or not, under the statute. And that's very different, by the way, from some of the other legislative changes that we've seen, which restrict new changes just to government entities. And the fifth category of concerns I have are, what does the statute say? What was the intent of the statute say about what a single state is entitled to do in our broader federal system? So I have 1 slide on each of these issues. Let me start on this, the definition of dominance. So we currently have a concept in our country for all the states and the federal law of prohibiting companies that have monopoly power or market power from abusing that monopoly power. This is a well understood concept in US law, although the definition is always evolving. It can be broadly defined. In some cases, courts have allowed these types of cases, monopolizations, unilateral conduct cases, to proceed where a company has greater than 50% of the market, sometimes only 30 to 40%, but it's highly fact dependent. But if you carefully look at the provisions of this statute, the statute proposes to adopt kind of like an assumption that 30 to 40% of market share is presumed to be a dominant position. Now, this is not, I mean, there definitely are cases where you can have market power at 30 to 40%, but there's also a lot of cases where you don't. You could be the 3rd biggest company in a market with a 30% market share. So it seems like adding in a presumption around 30 to 40% seems unnecessary, and also seems a little bit odd to me, because I understand, and Senator Gianaris can correct me if this is a mistaken understanding, but I understand this legislation to be targeted at the largest, biggest, most dominant firms in our nation. And so what is the purpose of having a special rule that, oh, yeah, if you only have 30 to 40% of the market, you're presumed to be dominant? The statute also has a provision that says that the unilateral power to set prices, terms, conditions, or standards, or dictate non-price contractual terms without compensation results in an inference of market power. Maybe in some certain circumstances that's correct, but again, it's very fact dependent. We're all familiar with standard forms that people need to fill out in different circumstances, so-called shrink wrap contracts. I believe that the idea that each one of those standard forms results in an inference of market power is over-inclusive and probably over-broad, and again heightens my concern that dominance, the term dominance here, is defined incredibly broadly, far, far beyond what is my understanding of the purpose of the statute. There was a recent amendment, if I read it correctly, that was trying to limit the statute to a definition of trying to exclude small businesses. I don't know that that's going to be an effective fix. You can have companies that have a large number of employees and would not be considered a small business under, let's say, a statutory definition, but they're still not, like you could have a hospital. A hospital probably would not be considered a small business under most statutes, but that would fall within the scope of this definition of dominance. Just based on my experience as an antitrust lawyer, I put in a number of industries that these are industries that under US law already, without trying to broaden the concept of market power or dominance, these companies already are considered to have market power, many of them. Hospitals, physician practices. I brought a case against tour bus companies we claimed had local market power when I was at the New York Attorney General's office. Grocery stores, waste management companies. All of these companies have been found to have market power, and so they likely would be, at risk of being caught within the language of this statute in terms of what is a dominant firm. So I guess I just want to highlight that the effort to expand the term of, U.S. understanding of what kind of firms are subject to unilateral conduct regulation. I mean, I applaud the effort for sure, and I don't dispute, at least for the purpose of this meeting, that it could be improved. But what we have in the statute, I think, requires a lot more thought and care to avoid sweeping in all of these other types of industries, which again have been found to have market power. Let me take this slide off because it doesn't necessarily, I'm not going to raise this issue yet, so you can see a bigger picture of me in the interim. So the first raise, so remember I had 5 issues I wanted to raise. The first issue is, we're talking about abuse of dominance, and I'm focused on the word dominance and expressing a concern that that term is too broad. Then my second concern is the word abuse of dominance. This does come from European Commission and other non-US precedents. And I think, the benefit for the drafters, I think, is that the idea is that we'll start from scratch in terms of what is an abuse of a dominant position as opposed to exclusionary conduct by a monopolist under current law. But that's also the downside, that we're basically starting from scratch under US law. We don't have any experiences. Businesses don't have any experience in the US figuring out how to do compliance with an abuse standard as opposed to exclusionary conduct. And I'm not really sure what this is entitled, what this language is supposed to capture. Is it aimed at mergers? Is it aimed at other types of dominant firms conduct? And I have some concern that a kind of, if there's a knee-jerk reaction to look to European precedent to define what is an abuse of dominant position, well, we're going to be looking at law that's developed under very different economic and cultural conditions. For example, US law at very rough, at a very rough level, some people have said, and I think there's support for this, that historically it's more pro-consumer, more pro ordinary people buying items than European law, which has been interpreted by some to be more protective of competitors. So there's a question as to whether, if we in the US import European standards of intervening to help competitors, are we going to unintentionally be adopting a legal regime that favors maybe not the biggest competitors, but the second or third biggest competitors at the expense of the public, at the expense of consumers? I don't think it can be denied that the US economy has generated the most innovative and disruptive technologies in the world. And we are not afraid in this country for a new technology to come in and wipe out the existing competition. And that is not the culture necessarily in Europe. And I think we may want to consider more seriously before asking our courts to follow the courts that, court rulings in Europe. Another issue in Europe is that they don't have an effective private system of enforcement. They don't have treble damages. They don't have a lot of class actions in Europe. And so I think what you've seen in the United States is some courts pulling back on the antitrust laws out of concern that this type of rule in the hands of private plaintiffs would be abused and it result in excessive costs to small, medium, and large US businesses. And so again, just importing standards from Europe were decided in a culture and economic climate of a lack of private damages is not necessarily it's not necessarily something we want to directly import without considering what is the effect of this rule if we put it in the hands of class action attorneys or other types of private plaintiffs that don't have the same publicly oriented incentives that, let's say, the European Commission has. Okay, that's not even the worst part. And I hope that maybe maybe Senator Gianaris will take this out of the bill after seeing this. Let's see if I can get this back on. You guys can see that?
Yep.
Okay. So the worst part of the bill, and I would really propose that this be removed, is that there's this section that seems intentionally to sacrifice consumers to competitors. And what it says is, I would be happy to hear a different interpretation, but what it says is, if you're engaged in conduct company and you think that overall it's better for consumers, let's say results in better safety, better privacy concerns, we don't care. That's not a defense. If it hurts a competitor, it's anti-competitive. And I'll give you the example that I've used in other talks about this, that it's a real world example. So let's say you've got a hospital system, a major hospital system, and they've decided, you know what, we're really concerned about anesthesia at our hospital and the level of training of the anesthesiologist. And what we'd like to do is have conduct an auction, and we're going to have the anesthesia practice that's willing to do the greatest amount of training and safety and best privacy practices. And they're going to be the exclusive anesthesiologist at our hospital. Okay, let's imagine that that's what's at issue. Well, the competing anesthesiology practice might be very angry that they've been excluded from practicing at this New York or California hospital. How can you exclude us with this exclusive deal? And by the way, the people that got in are the already dominant anesthesia practice, and that's wrong. And yeah, our people aren't as well trained as theirs, but that's not an excuse. And what this statute says is that evidence of pro-competitive effects, like benefits to consumers that, of the higher training, that the court can't even consider it. It's not a defense. No modern country has a rule that's like this section of the New York bill. No modern country, even in Europe. I say even in Europe. Europe has lots of good things about its system, but certainly they adopt the same rule as the U.S. does. That, look, we'll consider this contract. We'll consider whether it has pro-competitive effects. We'll consider whether it benefits consumers. We'll do a balancing test. So the idea that a business that is looking out for consumers can't even make a case about the benefits to consumers, it's not allowed. Statutorily, it's excluded. I would disagree with that.
Can I ask a question on that slide?
Please.
If, apologies, Mr. Stock, I'd like to ask you a question on the last slide, largely because I want to fully understand your point. I get the tactical advantage of suggesting that provision will kill people. So the selection of hospital personnel was a smart tactic. Can you give an example that's less inflammatory, that is focused on commercial reality, not medical safety?
Great question. Great question. So I'll give you another example. Let's say you've got a high-end product, let's say high-end coats that you manufacture, and you would like, you're concerned that you want people to come and see how good they are in person, and you want to promote retail sales at brick and mortar stores for your high-end coats. And, but you're concerned that people will come in and look at the coat at the high service retail store, and then they'll go buy it online from, a manufacturer somewhere else after getting all this public, service from the local retailer who's been educated and working together with the manufacturer. So in that situation, the manufacturer might want to enter into an exclusive relationship with this retailer and say, look, I'm not going to make this product available online. I'm only going to make it available in your store, and you're going to have the exclusive right to sell my product. And so that really incentivizes the exclusive distributor to invest in, learn about, have events promoting the product. But what about some other distributor that is upset that they're not getting access to this high-end coat? Or we could change it to some other product that more obviously could be accused of dominant. Let's say it's high-end printers or something like that. The idea is that consumers are better off by this system, which would allow a manufacturer to select an exclusive distributor who would invest in their product. But people who are not included will always complain, and they might want to sue. And I'm not saying that they'll never have a good case, but preempting the manufacturer's case by not even allowing them to say, well, look, this is overall better for competition and for consumers because I can't even really add these improvements in my product if I don't have people explaining how it works to consumers. So to be honest with you, exclusive agreements are all over the place in our economy. And the idea that you cannot defend an exclusive agreement from the party that's excluded because you can't even argue that it's pro-consumer, that seems wrong. Instead, the rule in every jurisdiction that I know of in the world is that both are considered. If you have a flimsy argument for exclusivity and the competitor has a better argument that they're excluded, then you should lose. But if you have a really good argument, it should be heard. So do you want me to continue or does anyone else?
Yes, please.
Can
Yeah,
I
okay.
actually follow up on that regarding hospitals? How is this applicable to not-for-profit entities? I always thought there's a distinction, right? Many hospitals are not-for-profit or religiously affiliated. So I was curious to see that you had that as one of the examples there. Can you help me distinguish between a nonprofit and a for-profit in this case and why you put that up there as a top example?
Sure. Well, there are a lot of for-profit hospitals. The antitrust laws do apply to nonprofit and for-profit hospitals. I don't recall if the honorable senator has an exclusion for nonprofits in his legislation. But there are plenty of, Tenet Healthcare, there's lots of for-profit healthcare companies out there. And I'll also say that the FTC has been pretty vocal about needing to enforce antitrust laws kind of equally, even for nonprofits. So I think it's a great point that there might be, nonprofits out there, but most antitrust enforcers that I'm familiar with are in favor of enforcing the antitrust laws fully against nonprofits. Although there is an exclusion for the FTC Act there, but it's a good point. I don't think it changes the power of the illustration, but it's a good point.
I don't see any other questions, so would you please proceed?
Yeah, I just wanted to make my two last points. So the 3 points I made are the overbreadth of dominance, the overbreadth of abuse, and the large number of other industries that could come under this. I did want to express my concern if we're going to be, treading new ground, heading into unexpected territory. I do think the combination of that plus allowing private actions, class actions is a toxic combination. We don't want to see a statute that's passed aimed at giant national companies, billions and billions of dollars large, and that's the intent of the statute. But then And that's probably how the California or New York Attorney General would enforce it. But we don't want to see that power and the placed in the hands of private parties when we don't understand necessarily what's going to arise from this, these new standards. And I think that if we start seeing, class actions being brought in state court against large hospital systems, again, as my example, but you could say, you could use physician groups or other department stores or whatever you want. It's a dangerous and potentially very expensive proposition for these businesses to be subject to these new lawsuits. Now, I'm not saying that they should be immune from antitrust law. They should comply with antitrust law. But the problem is when you have these very vague standards from European law combined with class actions, it's potentially an extremely expensive proposition for medium-sized businesses. Okay, this is my,
Mr. Stock, we have another question.
So I understand, and I'm sure if you have a different understanding, it'd be interesting to hear what that is that class actions are purposely meant to protect some of the most vulnerable people. Even in the example of the large hospital system, you've talked about how there's nonprofit and for-profit. People are drowning in medical debt. And they should have an opportunity to address what that means when we have, for example, these for-profit hospitals in which people are making a lot of money, and the people who are hurt and are in, dire need of medical service should have an opportunity to band together and to be able to challenge that kind of abuse of power. So wouldn't that be a good thing to have class actions? Class actions have a very specific requirements where the harm has to be proved and all of these different issues. So it seems that there are checks and balances between the class action proceeding process to ensure that it's not, these large private companies that are bringing, starting these proceedings. Wouldn't it be in the best interest to have these class actions for people that may be drowning in debt?
I think that's a great point. Let me first talk about what the Supreme Court and a lot of circuit courts have said about class actions, and we can talk about whether they're right or not. But they've said that class actions serve an important role in our system, and they do, because there are some kinds of cases that couldn't be brought unless it was a class action. Let's say because a consumer is only, let's say, going to benefit by $50 and the cost of a lawyer is way more than that. We need a class action to make sure that those cases can be brought and that there's enough deterrence of bad conduct. So I agree with that. But what the courts have said, and I think there's some truth to this too, is that in certain circumstances, class actions are so expensive, and antitrust is one of those areas where courts have said this. Class actions are so massive and expensive for businesses to defend that they are essentially coerced into settling, and the merits are never decided. And it generates a huge amount of cost for businesses, and not even necessarily the largest businesses. And so you've seen the Supreme Court, especially, but also the Second Circuit in New York, and other courts expressing really grave concern that under some circumstances, class actions are not about the merits. If the class action proceeds, the risks of a company taking the case to trial are so massive that the merits are never decided. I'll give you an example. I represented an au pair agency in a class action. There was something like a dozen au pair agencies, and the class action alleged that au pairs, it was on behalf of au pairs, and it was about their pay, or if they should be paid more, subject to the minimum wage. Let's say you have one of these small au pair agencies, they're responsible under the class action mechanism and joint and several liability for damages that the entire country felt. Just this one little au pair agency, if they lose a trial, they're responsible for joint and several liability for the whole industry for every single au pair. So how is a small or medium-sized business going to take a case to trial that will bankrupt it if they lose, maybe 10 times they'll lose damages 10 times the size of their own revenues. So I'm not disputing that class actions play an important role. What I'm saying is that they can be weaponized in certain situations to create massive costs for businesses, so the businesses don't even have the option to bring them to trial. And I'm expressing the concern that if we're going to be experimental about new standards to apply, standards that may result in excessive cost for business, compliance costs for businesses, standards that we don't know if they're going to be respectful enough of consumers' interests, that one option to consider would be to limit these experimental standards to public entities that we trust, rather than putting it in the hands of private parties who, the system is often good but not perfect, and so it is a dangerous combination. In my
Mr.
opinion.
Stock, we're running out of the time we've allotted for your segment, and the senator has a few minutes left, and I feel like I need to give him a chance for rebuttal. So if
Yeah.
you wouldn't mind unsharing your screen, we'll switch to the senator, and then
Sure.
and then we have to close this out.
Yeah. Thank you for the time, by the way.
Thank you, Mr. Stock, and thank you for your answers to our questions. Senator.
Thank you. I appreciate the chance to respond. What I would say after listening to that is, I'm a lawyer, so I understand the adversarial system of law that we have in this country. And Mr. Stock does an excellent job representing his clients, and he's got the knowledge and experience to do so. But he comes from a point of view. He started out saying, I recognize we need to change the antitrust laws, and then offered nothing but criticism of any effort to change the antitrust laws. And so it seems to me that the status quo is what he's actually advocating. And if you like the status quo, he is absolutely right. Don't change a thing. But I'm coming to this from the perspective of the laws that exist today are not working, and they're not protecting either competitors or consumers or the public at large. More specifically, he had mentioned that the importance of innovation and research and revolutionary ideas transforming the economy, and that's what America is known for. I wholeheartedly agree. But it is the big companies that we're trying to get at that are stifling that. When you suppress medium and small sized businesses from their ability to compete, you're losing the innovation. You're losing the opportunity for new ideas to break in. In fact, all we're seeing, especially in tech, is the big guys buying up everything else. And so it's almost like a business plan, come up with an idea that you could sell off to one of the 5 or 6 big companies that own everything in this country. And I don't think that's healthy for the economy. I don't think it's healthy for our country. One of the criticisms I also heard was that this is so new and unprecedented, it would require us to start over and not have guidance as to what the standards might be or where all this would go. And yes, I would say that's exactly what we're trying to accomplish. When the antitrust laws were first written over a century ago, I would say that the same arguments were made. That was a whole new field that business had no idea how to comply with. And over the years, I think we not only think they have been valuable, but indispensable. In fact, the criticism I'm leveling is that they've been weakened too much. And so we need to come from a new, more aggressive posture. And then finally, I would also add that there was a lot of talk of protecting consumers in that discussion, as opposed to competitors, and the importance of consumers. And not 3 minutes later, it went from protecting consumers to preventing them from having the ability to sue to enforce the laws on their behalf. And so the contradictions are many. The consistency is the protection of those that least need protection. And that is what we as arbiters, as people who are not representing clients in an adversarial lawsuit, people whose job it is to think about the public impact, and our clients, so to speak, are members of the public. It's our job to sift through all that and figure out what really needs to be done. That's what we've attempted to do here in New York. And by the way, we are working very, very closely with all of Mr. Stock's former colleagues in the Attorney General's office here in New York, who helped us draft this very bill. And so, I'd be curious to know about his conversations with some of them about this, since they are very heartily involved in advocating for this proposal. But I know, I respect Mr. Stock, and he's done good work as he always does in advocating his point of view. I just disagree on this one.
Senator, we have a question from one of the commissioners, if you don't mind.
And maybe for either or both. We've had a few presentations on antitrust principles and laws before today. And if I recall, one of the important distinctions was the distinction between a large company who, because of the quality of their products or efficiency of their businesses, becomes dominant. And that has a negative, being dominant has a negative effect on competitors, as opposed to a dominant company that takes affirmative hostile actions toward competitors to keep them out of the market. And it's the taking affirmative hostile actions toward competitors that I think we heard that violates, I guess, the Sherman Act, that as that's been enforced. Does this proposed bill still make that distinction, or is it the sort of business type actions that a large company makes, not particularly aimed at anybody, but they take actions that have a negative effect on competitors? So I don't maybe I
Has
have
been an intent.
yeah, it has to be an intent to
Yeah.
harm competitors.
No, I understand the question completely. It's a very good one. And I'm glad you gave me the opportunity to address that, because this proposal entirely maintains that distinction. What shouldn't be lost is that the two of the main points of the five that Mr. Stock made was he has a problem with the dominant standard, and he has a problem with the requirement for abuse of that dominance. Those are two distinct requirements. So being dominant is not a violation. Being dominant does not subject someone to enforcement. It is having a dominant position as a prerequisite, and then abusing that position, which would in fact require the intent and the kind of behavior that you asked about.
Okay.
And then Senator, we have one more question.
Actually, can I-
Senator, thank you again for appearing. I've got one question about looking forward versus backward. Too much legislation sometimes is focused on the problem of 3 years ago. So I'm curious, is your legislation looking forward in the tech sector? For example, on the monopolistic possibilities from generative AI, including with price setting, the open source closed later phenomenon, which is very effective in killing competition, and actually the ability of generative AI to collude and manipulate markets without a human fingerprint on it, which would seem to evade current statutes.
We have an entire element of our legislature focusing on AI related issues right now. So it's a good question, but I'm not a futurist, right? What I can do is plan for unexpected events, but I can't predict what's going to be happening 5 or 10 years from now. What we have done is built into the proposal the flexibility for the Attorney General to establish regulations going forward. And so if some new tactic should develop that becomes a problem, or if some unforeseen element of implementation of this law takes place, they can establish a new regulation, which would be subject to legislative veto, just so we don't put the Attorney General in the position of legislating and create constitutional problems that way. But we do have the flexibility for new ways to enforce this law to be brought to the fore by the Attorney General, subject to legislative oversight.
Thank you.
And Senator, one final question, if you don't mind.
Sure.
Great. I actually have a question for both of you. So Senator, you indicated that there are industries that you don't want to touch. Can you give us examples of those industries and why you don't want to touch them? And Mr. Stock, I have a question for you. What have been do you believe have been your most effective strategies on opposing this bill? And how have you gone about implementing those strategies?
Should I go first?
Sure.
Well, one example was actually raised, which is we heard from small businesses that we certainly didn't want to capture that they were concerned about someone pointing this, weaponizing this proposal towards them. And so we have exempted small businesses specifically. Mr. Stock mentioned the hospital example. We have heard from hospitals who are concerned as well. And we are talking again with the Attorney General's office here in New York about making sure we don't have some kind of unintended consequence on the exact types of examples he mentioned, which we're certainly not trying to put anyone in danger. I don't think the bill does that, but I find in a lot of instances, in an effort to bring calm and comfort to people who we're not trying to get at, nor do I think this bill would get at, that we be crystal clear, just to give them comfort that that's not at all what we're getting at. And so that conversation is ongoing. As I mentioned, I think our sessions run from January to June, so we're a couple of months from the next one. I think you're likely to see a slightly different iteration of this bill in the next session, but I would say 95% of it is as you're seeing it.
So I'll try to answer your question too. I mean, the way I interpret it is what criticisms of the bill have resonated the most when we've made them. And I think in large part, as I said, I think we all share the same goals here. We want to curb the power of large companies. We want to have a more equitable distribution of power. The question is implementation. Is this an effective implementation? And I think what's resonated the most from from people that have listened to what I've said is the lack of connection between the implementation of this statute and the goals. Like why do you have to have low market shares be dominance if your goal is to curb the powers of the very largest, biggest companies? There's also a rule, the Dormant Commerce Clause, about a state's inability to regulate competition outside of its own borders. And so I think what's resonated when I've been talking is the idea that this law was passed intended to affect large national companies, but it's interpreted like there was a California statute against reverse payment settlements by pharmaceutical companies where the Ninth Circuit held that it couldn't be applied outside of agreements in California. And so again, the only effect is on local businesses or conduct within one state, and it's not effective in regulating national commerce. And that's kind of to the disadvantage of the state. It discourages companies from locating in the state because they're subject to a rule that nobody else is. So those are two things that I think have resonated quite a lot. And this idea that the statute as written right now with that special provision provides that even conduct that's beneficial to consumers, that's intended to promote safety, it doesn't matter if a competitor claims they've been excluded. I think that critique has resonated a lot. So I think it's at a broad level, I'd say the lack of connection between the goals and the implementation is what resonates, because I think most people think something should be done. And so, but it resonates with them when they see that this implementation doesn't really accomplish what it seeks to accomplish and has all these potential collateral effects.
If
Gentlemen,
I can make a final point, I'm sorry.
Yeah, we have about 5 minutes left. I'm going to let the senator go, and then our executive director had a couple of things for you too.
Great. I'm glad Mr. Stock returned to that pro-competitive thing, because I did want to address that as well. What's happening currently is all sorts of abusive and anti-competitive behavior is being excused because companies will roll in with the proof of competitive effect, and that excuses a lot of what's going on. So we're trying to restrict the ability of that to happen, and the courts have been too permissive in allowing that to happen. This is one of the particular elements where we are fine-tuning. We're actually awaiting new draft language from our Attorney General's office to tweak that part of it. We intend to maintain the approach of restricting the way that it's being handled currently, but maybe Mr. Stock will be happier with what we come up with by January.
Right.
Thank you. Just a few quick questions. One was, Mr. Stock, you talked about how U.S. companies aren't familiar with the European standard, abusive dominance. Are the large companies that have markets in Europe subject to the abusive dominance standard for their businesses there?
Yeah, I would say the biggest companies do have that experience, like Microsoft and other companies that have been subject to lawsuits in Europe. They do have some experience like that. I guess what I was referring to were the kind of medium and less large, but not that large businesses. You know, there's a lot in between a hospital and a large tech company, and they don't necessarily even operate in Europe. For example, many large hospital systems, many physician practices only operate in the US. Telecommunications companies often may only operate in the US. So many companies that would be hit by this legislation do not have European operations.
Okay, thank you. Senator Gianaris, when you were talking about the example of online sales platforms using leverage to privilege their own products, you said that might happen even if their products are inferior or more expensive, which to me seemed like you were pointing at less advantageous to the consumer. But that's not the only conditions under which the standard might operate, right? I mean, it doesn't have to be less advantageous to the consumer under an abuse of dominance standard. Is that correct?
Correct, yes. Restricting the competition in and of itself would be part of the problem there.
Thank you. And the last point is, I guess, for Mr. Stock, and pardon my ignorance, is pro-competitive effect a term of art in antitrust? Because the example you gave of choosing an anesthesiologist firm that has higher standards didn't seem like an example of my lay understanding of pro-competitive. It was pro-patient's healthcare standard. So is it understood in this area of law that pro-competitive effect means any kind of good justification for the anti-competitive abuse?
So it's a great point. I don't know if I have the definition is exactly right, but when I'm using the term, and I think when many people use the term, they mean ultimately pro-consumer, better for the consumer, from a utilitarian sense of better outcomes for more people.
Okay, and while that may not be available under Senator Gianaris's bill as a defense, could it be folded into the question of whether there is abuse?
I don't think so. I think that provision maybe is in the works, that there'll be a revision, but the problem is that section provides that in claiming there's no abuse of dominance, you can't say that this is not an abuse of dominance because I did this to benefit patients, because it's going to increase privacy, it's going to increase safety. You can't say that to defend against abuse, and I think that's the key problem, or a key problem.
I think we have one final commissioner question.
Thank you.
Hi, Mr. Stock. With regard to your criticism of the 30 to 40% criteria, have you and your clients posited a different number?
No, but I guess my question would be it does depend on the circumstances. For example, like there's been some litigation against the credit card companies where some of the courts held, look, I just think each credit card company, Visa, MasterCard, and maybe even American Express too, they're all kind of dominant because no retailer can live without them. And so in those cases, there's been finding that even low market shares can be dominant. But then you can imagine lots of other scenarios where, there's three players that are battling it out and they're all about 30% and none of them are dominant. So I think my concern is, I don't think we need a presumption. I think it should be just based on the facts, whether a party is dominant or not. I don't feel the need to kind of tilt the scales against the party with 30 to 40% market share by creating a presumption.
Gentlemen, I really thank you for your contributions, helping us unpack and come to grips with this very complex issue. It's been very beneficial hearing about the experience in New York and your respective perspectives on this matter. We look forward to hearing more from you about this as it develops. Brian, anything else?
Not from our presenters, no. Thank you very much.
Thank you.
Thank you both, gentlemen.
Thank you.
Thank you.
You're welcome.
And I think complete the antitrust, since we're on this topic. The the memo served as a vehicle for attachment of a couple of letters we got, so those are attached. You should review them. I think we're going to get lots of letters, and we'll continue to present them mostly without analysis, just so that they are part of our record, but you should read them because, valuable insights. The only decision point in this memo is that I had proposed at the last meeting and am re-upping the proposal at this meeting that the commission authorize the hiring of a consultant for this study. And the memo lays out my concept of how this would be structured and what the consultant would do for us. And it proposes that Cheryl Johnson be selected as the consultant for the reasons I lay out in the memo. She's been extremely helpful in the study. She knows all the players, but the thing that struck me most about her background as advantageous for our process is that she's got over 30 years as the editor-in-chief of the California Treatise on the Cartwright Act. And as I suggested in the memo, helming that kind of a project means working with lots of lawyers from all different perspectives and sort of managing to get them to some level of consensus in terms of presenting a fair distillation of existing law. So there's a number one, there's sort of a herding cats experience that I think is going to be valuable. And the other is that has proven experience in terms of producing an even-handed practice treatise that I think wouldn't have been as successful as it has if people thought that it was tilted one way or the other. So that's my recommendation, and the commission needs to make a decision on that because our handbook requires commission approval of such contracts.
Thoughts, discussion?
I think she sounds great.
Makes sense.
Positioned to
Yes.
address the issues that are going to be coming up.
Yeah.
Yeah.
I'll move approval.
Second.
Okay, so I'm going to call roll.
Nope.
Carrillo.
Aye.
Carrion.
Aye.
Cubas.
Aye.
Hebner.
Aye.
King.
Aye.
McAllister.
Aye.
Simpson.
Aye.
It's been approved.
You're out of focus.
Oh, we are.
What
Oh, I'm
happened?
glad it's not just me.
Artsy.
Some of us might.
So Chief, do me a favor and like wave your hand in front of the camera.
Maybe it just needs to see us again. Maybe we all need to move closer. It might be a good time to
Put on your glasses.
move to administrative business anyway, which is less critical if they see our faces.
Before we move on, I just want to confirm that we're going to receive the presentation that was from Mr. Stock, and that's going to be uploaded online, so that way the public has access to that as well.
Yeah, the video is being recorded, and barring some technical gremlins, it will be uploaded to our website and our YouTube page.
Okay.
Like all the meetings, everything should be available.
Yeah,
Yeah.
so were we at the time. I don't know where the technical people have